Hi, everyone, and welcome to Relationships and Family Planning. We are just getting started here, trying to get Tim on our camera and our microphone. There he is. It worked. Say something.
Hello, can you hear me?
Oh, wonderful. Perfect timing, Tim. I was just getting started. Um, Tim's going to talk to us about, as I mentioned, relationships and family planning. Um, Tim is our friend and colleague. He's an estate planning attorney, and he's done a lot of these classes with us. Tim, I switched over to this slide has the wrong title, so I just switched to the agenda because this says wills versus trusts. Um, there we go. So Tim's going to talk to us a little bit today. For those of you who haven't met him, he's wonderful. He works in the tech center. Downtown. He works downtown and helps a lot of our people with a lot of estate planning and wills and trusts and those kinds of things. But today he's going to talk more about the marital side of law. And as always, if you have any questions, you can type them into the box on the right hand side, and Tim will graciously answer them. And after that, we'll have a little chat about our upcoming classes. And I'm gonna turn off my camera so you don't have to just watch me watch Tim. But I'll pop in if I need it. I'll just be listening here. So go ahead and take the stage there, Tim.
Excellent. Thank you so much, Colette. I appreciate the warm introduction. And I was just thinking about how it seems like the past couple of times we've always had this last minute sort of nervous anticipation as to whether or not our technology is going to work. This time I was having trouble getting my camera connected. And of course, at the very last second, we can somehow get it going. So I'm glad to be here. Thank you so much for allowing me to come and present and hopefully educate us on this topic. The other thing I was going to just disclaim for you is we've got the air on in our building, and for some reason, on really cold days like today, it will sort of sound like maybe a plane is taking off or something. So I apologize if that is a distraction, and if you need me to repeat something or can't hear something quite well, just let me know. Um, Such a timely topic. I've had several meetings in the past couple of weeks of people wanting to ask about prenuptial agreements. I had one client we were doing an estate plan for, and he told me that he was going to be proposing to his girlfriend that Saturday. And he did email me the next week and told me that she said yes. So that was good to hear. But a lot of that stuff affects someone's estate plan. And so I like to sort of start with this overarching theme that when you're in a relationship with someone else, there are legal ramifications to that. And so hopefully today's presentation will talk about some of the types of relationships that we see and what those legal ramifications are from an estate planning perspective. And what we want to think about is not just maybe your own relationship, but oftentimes people think about their children's relationships and how they might be inheriting, or their spouses might be inheriting, and what rights they have. So that's where this comes up, and it is a very much a parallel topic with estate planning. And so we can jump into it. The agenda you can see in front of you, where I'll talk about some just general information on marriages and statistics and things like that. And then we'll look at some of the relationships that we see specific to Colorado, and the nature of those relationships in very broad perspective. And then we'll take a look at what the ramifications of relationships in marriage is, what those would be. And then how do people plan for their estate planning based off of their relationship? And so that's what we'll take a look at today. I've just realized recently in preparing for this that I probably should update my statistics. 2017 is very quickly fading. It seemed like it was pretty up to date a little while ago, but now we're coming up on 2022, right in the middle of it here soon. But here's some of the statistics on relationships. In 2017, about half of Americans over the age of 18 or older were married. And there's some of the reasons there for marriage. Number one is the reason is love. So that's excellent. I think that's a good reason to get married. And then also keeping in mind that cohabitation prior to marriage or even without marriage is on the rise, especially in adults ages 50 or older. Um, a second marriage is also on the rise, remarriage. 4 in 10 new marriages involve a second marriage. And a growing number of marriages involve different views on religion. That's fine, but it is becoming apparent that you cannot have different views on politics. And so there's just some general information broadly about relationships. As far as Colorado specifically, very similar statistics. In 2018, I don't know how to relate that to anything there, but about 7 or 8 people out of 1,000 people were married. The same year, the divorce rate was 13.52 out of 1,000 people were married. So there's a lot of divorce, and we'll talk about how divorce might affect someone's estate planning. I thought this was interesting that the overall cost of a wedding in Colorado is around $25,000. So if you're budgeting for your children, maybe that's, or for yourself, maybe that's something to keep in mind. Some of the top cities in Colorado to get married include Denver, Colorado Springs, and Boulder. And so there's some marriage information in Colorado. Now, just culturally, we're looking at some paradigm shifts, and maybe you have seen these in your own lives or in the lives of those around you. But marriage rates used to be a lot higher. In 1950, married households were about 80%. Today, it's closer to around 50%. So marriage itself is lower than it was. However, that seems to sort of be made up for in cohabitation. A lot of people decide to cohabitate without getting married. And we'll talk about the nature of that relationship. In 1960, 59% of that age group there were married. Today, the age group of 18 to 29, so right before you're 30, today it's around 18% of that age group is married. So that's a dramatic drop in the percentage of people younger who are getting married. Blended families are also on the rise. And when we refer to blended family, we'll define this for you. But basically, it means a second marriage with kids from a prior marriage that end up merging into a blended family. And it's also a lot more common for people who have children to be together but not be married. So we see that as well. And of course, very many years ago, that was practically unheard of. Okay, so that's just some general information on the demographics of marriage and blended families and remarriages and all of that as far as it relates to relationships. Now, let's look at sort of what the marriage process involves. As far as getting married in Colorado, and by the way, you can find this on a lot of photographers' websites because the idea is they provide you with the information and then you hire them to take pictures at your wedding. But you do not have to be a state resident to be married in Colorado. You apply for a marriage certificate in person at the county clerk's office, and you have to have a valid ID, which includes those forms of ID. You have to be 18 years or older. And then once you obtain the certificate, you have to get it signed and returned to the clerk within 63 days of the wedding. People who can perform wedding ceremonies include judges, magistrates, public officials, clergy, or ordained family or friends. So that's sort of going through the process as far as getting married. Now, throughout this presentation, it's possible that I will use the phrase traditional marriage. And what I'm talking about is the traditional marriage ceremony. I'm not talking about gay rights or heterosexual marriages. What I'm talking about is the traditional marriage ceremony. In other words, going through and getting a certificate. So if I say that, that's what I'm talking about. Civil unions, we'll talk about common law marriage. That's a really big one. I had a conversation last week with someone, and at the end of the conversation, it sort of ended where they needed to decide, her and her significant other needed to decide if they were common law married because they probably had enough evidence to prove that they were. But at the end of the day, they both needed to sort of agree on that. Some other forms of relationships include cohabitation agreements, domestic partnerships, and then, of course, we'll talk about premarital and antenuptial or marital agreements, postmarital agreements, before and after the marriage. Okay, so here's some of the relationships. As we discussed the traditional marriage ceremony, we have already kind of gone through that. So that was what you do. You get the certificate, you get it signed, you return it within 63 days. There's also the relationship of a civil union. And that first became effective in Colorado in 2013. Now, the point behind a civil union was very much in response to the lack of legalization of same-sex marriage. People who were not able to get married because they were same-sex would often enter into a civil union. Some of the requirements for this include people who are not married to each other or to anyone else. They are over 18 years old. They're not related. They fill out an application and then they get that application certified within 35 days. Now, going through that process gives those two individuals some of the same rights that you would have as a married couple, including rights upon divorce to the disposition of assets, inheritance rights if one of the partners to the union passed away, owning joint property and things like that. Now, one of the big differences was in the eyes of the IRS. The definition of marriage in the eyes of the IRS did not and does not include that of a civil union. So entering into a civil union did not give someone the same tax benefits that you would have if you were married. We hardly ever see this form of a relationship after the legalization of same-sex marriage. And so now that that is pretty much universally applied, very few people will opt to enter into a civil union because the commitment and the rights that you have there, you have the same thing in a marriage. It's just that you also have some tax benefits as well that you would have in a marriage. So this form of a relationship was quite popular back before the legalization of same-sex marriage. Now, we hardly ever see this form of relationship. The next one here is common law marriage. Now, this is a big one. This is a topic that comes up with some frequency. Here are a few states that allow common law marriage, and you'll notice Colorado is right up there at the very top. Now, some of the states, they have some caveats, like New Hampshire, for example. The only reason you would be common law married there is for inheritance purposes. You don't get really any other benefits out of it, but you do have inheritance benefits if you're common law married in New Hampshire. Every state has their own requirements for how to become common law married, and we'll go through Colorado's. Now, one thing to remember is that if you become common law married in one state, and that's a valid marriage, then all of the other states, regardless of whether or not they recognize common law marriage, have to give validity to that marriage. So if you become common law married here in Colorado and you move to a state that does not recognize common law marriage, for example, I don't see California on that list, so you move to California. Well, that doesn't mean that your marriage is invalid. Because you were validly married here, you are also validly married in the state that you moved to. And so all states have to recognize that. The issue there becomes proving that you became validly married here while you were here before moving. And so it comes down to an issue of proof with regards to that. So let's take a look at some of the requirements for, well, these are actually all of the requirements for becoming common law married in Colorado. And just to sort of get you thinking, I asked this question up at the top: are you accidentally married? And that was, it was really an interesting conversation with this couple that I had last week, because when we went through it, the realization that they were likely common law married was a pretty heavy thing to realize for them, because that's an added level of commitment that's not there until you become married. And so when we went through this with this couple who were happy and in love with each other, and we discussed these requirements, at the end of the conversation, the conclusion was that they probably were common law married. And that was a big deal. And of course, it is a big deal. So we want to be careful about if and how these requirements are met. The requirements are found in Colorado Revised Statutes 14-2-109.5. That statute, that section, tells you exactly what the requirements are. It's going to be worded a little bit differently, but I've summarized them for us on the screen here. Number one, the parties have to agree to be married. So if one party agrees to be married, but the other party did not agree to be married, it doesn't matter. This fails. The other thing there is that they live together. So maybe they meet the other two requirements and they're planning to move in together, but they haven't moved in together yet. Well, this fails. They're not married. And then the last one there is that they hold you hold yourself out, or you pretend to be married. So those are the three requirements. And of course, we'll talk about how to prove that in just a second. If those three requirements are met, then you are married to another person. And the misconception there is that that is a sort of a different type of marriage than going and getting a marriage certificate. It's not. It's the exact same. You have the exact same rights and benefits as you would if you were validly common law married, as you do if you go and get a marriage certificate and go through the traditional marriage ceremony. So it's not different at all. It's just a different way to get to the same place. So if you meet these requirements, you are common law married. There was a court case a little while ago that we went through. The district court found that these three requirements were met, but the district court also found, because of some other circumstances, maybe the parties had separated or something like that, that there really wasn't a good basis to say that they were still married. And so the district court determined that the parties were not married. Well, the appeals court higher up, they looked at this case and they reversed it. They said, no, that's not true. Because these three requirements are met, it doesn't matter what other circumstances are out there. If those three requirements are met and the couple has not been divorced, then they are married. And it reversed the opinion. A big misconception here is that just because you live together for a long time, that means that you're married. Well, we've lived together for 11 years now, so I'm pretty sure that we're common law married. No, not necessarily. Just living together is not enough. You can live together and that's fine. We also have to have those other two requirements to be met, that you agree to be married and that you are showing other people that you're married, or you're holding yourself out as married. So how do we prove those other two requirements, that you agree to be married and that you hold yourself out as married? Well, it all comes down to the evidence. And no one particular piece of evidence is going to be absolute proof. You might have one or two or four of these things, and you might still have other evidence that proves you're not married. So it's going to come down to the weight of the evidence for and against the marriage. But here's evidence that is commonly accepted to show that the parties are married. They refer to each other as spouses. And you would go and you would get a witness or a neighbor to swear and say, yes, I heard them say that they were married and that this was their husband or this was their wife or whatever it may be. Maybe you share everything jointly, you have joint property, you have joint finances, joint accounts. That's evidence that you thought of each other as married. Maybe one of the parties has taken the other party's last name. Maybe they filed joint taxes as a married couple. Or maybe they have other documentation that proves that they are married. Oftentimes, in fact, I should say, anytime you work with us, we will make a statement regarding your relationship in your will, if you're married or if you're unmarried. And so we make that's evidence that proves what you signed. You said, I'm unmarried on this date. And so that's evidence to show what the status of your relationship is. Maybe you give each other an anniversary card on such and such date because that was the date that you talked about this and agreed to be married. So that's all ways that you might prove that you are married. And then you would meet the requirements of being common law married. Now, here's the big part to remember about common law marriage. Let's say you go through the process, you move in with somebody, you agree to be married, and you start acting like you're married. You are now common law married. You've become married. So what happens if you break up? Can you just unwind the process in the same way? Can you just move out and then just agree to be divorced and then just agree to go your separate ways and stop referring to each other as spouses? Well, the answer is no. If you become common law married, which is a valid form of marriage in the state of Colorado and several other states, there's no such thing as common law divorce. In order to become divorced, you would have to, at that point, go through an official divorce proceeding in court or legal separation. So that is the I don't want to say downside to this form of a relationship, but that's definitely something to consider, because oftentimes younger people especially will get into a relationship like this, and the commitment level there is such that, hey, they're living together, they're happy, and okay, yeah, let's get some tax benefits, let's act like we're married. And then let's say something happens to where the parties want to separate. Well, at that point, to unwind it involves a court. And if you do not do so, notice the second point there. Failure to do so means that you're still married. And if you're still married validly to someone else, you can't get remarried to another person if you should meet another person. So that's something to think about, that's kind of sticky with this whole thing is, hey, it sure is easy to get married. It's not as easy to get divorced if that were to come up. And so that's something to be careful about, knowing the status of your relationship, knowing what you've decided, and then making sure both spouses are on the same page if that does apply. We mentioned this earlier, not all states have common law marriage, but they are required to recognize a valid marriage in the state of Colorado. Any other state is required to recognize that as well. And then the issue there becomes proving it. If you've moved and it's been a long time and you've got to go back and find evidence, that could be really difficult to prove. Okay, so that's common law marriage. And again, I'll emphasize this one more time, that if you become common law married, that holds the exact same rights, obligations, benefits, and duties as a regular or a traditional marriage. And so that's something to keep in mind. All right. What about people who live together, but they are clear that the status of their relationship is that they're not married? Cohabitation, or living together. Well, there's a relationship, there's a way for them to memorialize the status of their relationship and their rights and interests while they are together. And so it's very similar to like a prenuptial agreement, except it addresses the form of the relationship where you're just living together, you're just cohabiting, and you're not actually married or in a further relationship. So cohabitation agreement comes up. Again, this is a big one, especially for older people who maybe a spouse has passed away and they've got a friend or a boyfriend or girlfriend that's moved in, and they're living together, but both parties have significant assets and they want to protect those assets in the event that one of them dies or that one of them ends up leaving. And so in that situation, they can memorialize this appropriately through a cohabitation agreement. There's some other ways to refer to this type of agreement. It could be considered a non-marital agreement or a living together contract. Those are all synonymous. And as I said, it functions similar to a prenuptial agreement. It dictates how the property will be distributed during the relationship and upon separation. It can also include planning for disability management if one of the parties becomes disabled or incapacitated, and it includes planning for death, setting forth the rights that each other have in each other's estates. And so that's a good way to do that. So why would we consider this type of an agreement? Well, there's a famous case. Everybody references this case when this comes up. It came out of California, and it's the case Marvin v. Marvin. In that situation, it was a cohabitation arrangement, and the parties split up, and they ended up going to court against each other. And the court found that this type of a contract could be considered either oral contract or written. So you would not have to approve this with a written contract. You could just say, hey, this is what we both verbally agreed to. Imagine trying to sort that out and prove what's going on there. So that's one thing to think about. You wouldn't want to be in court fighting over what the other party said with no evidence. That's a very difficult situation to be in. It could also, it doesn't even have to be stated, it could be implied. Maybe it was implied that one of you bought the really nice TV, but you bought it for the other person. And it was clear, everybody knew what was going on. I'm seeing some comments there, okay. Sorry to have you leave there, but hopefully you have a good day. So your agreement might just be implied by the actions. I was thinking about maybe if my wife buys me, I don't know, a lazy boy chair. Well, she bought it, and that's a bad example because we're married. But let's say we were cohabiting and she bought it for me, then that's implied that it's mine, even though she bought it. So it could be implied because of the actions, or it may be that the court just decides unilaterally that they know what's fair for the couple, and so they're going to split up the assets based on what the court decides is fair, and that the couple intended to deal fairly with each other. So this case stands for the principle that a court may end up deciding for you if you don't set it out in writing, the status of your relationship and what your agreement is with regards to each other's assets. So we all obviously highly recommend that someone detail this ahead of time and go and work through this, even if it's uncomfortable, because again, you don't want to be in court trying to see what the judge is going to decide. So that's a good reason to do a cohabitation agreement. All right. What about domestic partnership? Domestic partnership is often thought of very similarly as a civil union. You have two people who basically sign an agreement that they are in a relationship, that they are each other's sole domestic partner. They're over the age of 18. They share their life and home, and they are not married and not related to each other. So that's an affidavit, a sworn statement that those are met. Now, the rights and obligations that you have are similar to a civil union, but they're actually a little bit less than a civil union. You have certain rights regarding pension and health insurance coverage. You do not have tax benefits as a married couple because that doesn't meet the definition of a married couple under the IRS. You might have the right to pursue a wrongful death claim if one spouse was killed in an accident or something like that. The other partner, I should say, could potentially pursue that as a wrongful death claim. And then there's also possibly the right to privileged communication, which means you can't be required to testify against your spouse in a court of law. So those are some of the rights that you have under a domestic partnership. That's another one that is greatly faded because of the legalization of same-sex marriage. I have seen this. I have not seen a civil union come across my workload, but I have seen a domestic partnership come by. Okay, what about these types of agreements, premarital and antenuptial agreement? I think we're probably all familiar with sort of how they work and what they're for. A couple of things to keep in mind when setting up a premarital or postmarital agreement is there's a couple of things there that are in the middle. First is full and fair disclosure of all the assets and liabilities. So you have to disclose what you have, what you owe, and now a new addition to this is your income. We want to see your income for the past 3 years. And so you have to disclose all of that. Now, I had someone get really hung up on this, and they were really curious, why? Why do you have to tell the other person what you have? And the idea there is that you have to be able to make an informed decision. If you're agreeing to give up all of your rights and entering into this relationship, well, how can you do that if you don't know what you're giving up? So you have to know, okay, this person that I'm entering into a relationship with is worth $100 million, and I know that if they die, I'm not going to inherit anything. Well, if you didn't know that, you might not have signed the agreement. The opposite is true. Let's say that you're going into a relationship and you sign an agreement like this, and you end up getting married, and you find out the person has $100 million in debt. Well, you probably would not have signed this type of an agreement. So you have to have full and fair disclosure of the assets to make an informed decision. We also strongly recommend for enforceability that both of the parties have their own attorney look at it, because then it's not going to be construed negatively towards one of the parties. If both parties are represented by counsel, then that puts them both on fair footing, presumably, and then they can both agree to what they decide. And then the timing of this sort of an agreement. You can't do it too early and you can't do it too late. If you do it 5 years before the wedding, well, that's enough time that someone's assets might have significantly changed. Even 2 years is enough time. So it has to be close enough to the wedding, maybe 6 months out or somewhere in there. But you also can't do it the night before the wedding. And that's a classic example of waiting too long to sign this type of an agreement, because if you wait too long and you tell your spouse, hey, sign this agreement or we're not getting married tomorrow, that looks like coercion, and that's usually not treated as enforceable. So those are some of the things that speak to the enforceability of the document. One thing that a prenuptial or a postnuptial agreement cannot do is it cannot determine child support or custody. And this type of an agreement does have to be in writing. You can't go to court and say, well, we verbally agreed to this type of things. No, it has to be in writing to satisfy the statute of frauds. So these are some of the things to keep in mind about a premarital agreement. When it comes to premarital agreements, often that can be sort of an uncomfortable conversation with your spouse or your significant other. And so I will always tell the client to blame it on me as the attorney. Hey, go talk to your spouse and tell them that your attorney told you to ask about a prenuptial agreement. If it's going to be uncomfortable, if you're both not on the same page, perhaps, or you're concerned about that, then blame it on me. I'm the cynical attorney that will be the bad guy here if you need to. And by the way, anyone watching this, feel free to use that as well. Hey, I saw this presentation. The attorney told me that this is really an important thing to consider, because it is. It really is. And you can blame it on me in that way. Okay, I thought this was kind of a helpful chart to sort of see the hierarchy of the relationships that we've talked about. Now, this doesn't necessarily mean different rights, because the first and second one there, traditional marriage ceremony and the common law marriage, they actually have, again, the exact same rights and obligations as each other. It's just, it comes down to the level of proof. Proving that you're common law married makes it a little bit harder than going through a traditional marriage ceremony and getting a marriage certificate. So that's why it's right underneath the marriage certificate there. Then you have civil unions, then you have domestic partnerships, and then you have cohabitation agreements or arrangements. And so that's kind of the hierarchy of the relationships. So wherever you fit in one of these, maybe you don't fit into any of them, that's fine too. But wherever you or your loved ones fit into one of these categories, there are legal ramifications to that. And so that's the next part of this presentation, as to what are the ramifications of being in a relationship or being married to someone else. Well, let's start with marriage, and because we already talked a little bit about cohabitation. With marriage, there are some specific rights that you have against your spouse, or I should say towards your spouse, that are there because of state law. And the only way to avoid those rights is with a prenuptial agreement. So if you do not have a prenuptial agreement or a postnuptial agreement, Colorado law, statute 15.11.202, stands for the law that you cannot disinherit your spouse. So if you are in a relationship, then your spouse is entitled to inherit something from you. Now, this is subject to some limitations, but there's sort of a percentage formula that is applied, and your spouse is entitled to approximately 5% of your assets for every year that you've been married, up to 10 years, or a maximum of 50%. My wife and I were coming up on 9 years this year. And if I were, let's say in my will, I were to write and say that I do not want her to inherit anything from me, I'm disinheriting her. Well, because we've been married for 9 years, she would still have the right to claim 45% of my estate, regardless of what my will says or trust says or anything like that. So that's the inherited rights that someone has when they are in a marriage towards someone else. Now, there's a couple of ways that this applies that can create conflict. One is common law marriage. So let's say that my spouse and I are in a relationship, and we haven't talked about whether or not it's common law marriage or not. And let's say that I have a few kids from a prior relationship, and those kids are expecting to inherit everything from me if I die. Well, I pass away, and I didn't have a will or something like that. And so my spouse comes along, my spouse comes along, and she says, we were actually common law married, and we were married for 10 years. And so I get 50% of this estate. And my kids from another relationship they come back and they say, no, you weren't married. We didn't hear dad call you married, his wife, and we don't believe that you're married. Well, now there's a dispute over the status of the relationship. And guess who's notably absent from that dispute? Me. I don't have any way to say what I thought the status of the relationship is because now I'm deceased. So that's an example of how common law marriage can create conflicts. Believe it or not, this comes up a lot more than it should. We have situations, we have a case right now where someone came forward and they were able to get themselves appointed as the personal representative. They were able to get death certificates out of the estate because they said that they were the common law spouse of the decedent. It comes out, we review the evidence, and we find out that's actually not true. They were not common law married, but at the time of death, they were able to say that, and nobody could counter that argument because the only person who really knew was now deceased. And so that happens from time to time. It's very unfortunate, but it's a way to set up people for conflict if you're not clear on the status of your relationship. We'll go through this example here. This is another one. Let's say that in my will, I leave everything to my spouse outright. And what I want is I want all of my assets to go to my spouse, and then I want them to go to my children. Well, if my spouse enters into a new relationship after I'm gone, and let's say they're in that relationship for 6 years, the example there, W remarries and is married for 6 years, then on my spouse's death, her new husband gets 30% of her estate, regardless of what I wanted. So that's something to keep in mind with regards to what we call I love you wills. And I love you will is saying, I love my wife, and so I'm just going to leave everything to her, or she loves me, she's just going to leave everything to me, and not protecting against possibility of remarriage or cohabitation or something like that. So you have an inheritance right. If I could summarize this slide, I would say you can't disinherit your spouse absent a prenuptial agreement. Okay. There's also rights. Let's say that there's no will or anything like that. There's also rights under intestate. If you die intestate, then that simply means that you did not have a will. You didn't have a will or a trust to decide where your assets go. And so Colorado law has decided for you under intestate succession, and that's found at 1511-102. So if you die with no estate planning, you died intestate, and basically what happens is that the court here in Colorado determines for you what they think you most likely would want to have happened to your property. So in that situation, if you're married, your spouse is usually going to be entitled to a much larger portion of your estate. And it accounts for all types of relationships. If you have children from a prior marriage, or if you have living parents or living siblings, it's just up to the court to decide and what formula they apply based on your family relations. So if you're married, you have priority of inheritance from someone else when there's no will. You also have priority to serve as the personal representative, which is why this fraudulent person was able to manipulate things, because they have priority, and that's correct under law. In her situation, she was not married, so that was a fraudulent thing on her part. Okay, so you have intestate priority as well. There's also, and this is sort of following the theme that you cannot disinherit your spouse, there's also beneficiary designation things to think about as well. So if you're not familiar with it, a beneficiary designation is something that you fill out based on an account or retirement fund or life insurance policy. And what you're saying is you're entering into a valid contract, and you're saying, at my death, I want you to pay the proceeds of this to this person or this trust or this my estate. And that's a contract that you've entered into. The institution is going to follow the terms of that contract. Now, if you were to get divorced, so let's say you list your spouse as your primary beneficiary, but then you get divorced. Well, in that situation, the institution isn't necessarily keeping track of your relationship status. Most likely they are not. And if you pass away and you forgot to take your ex-spouse off of that contract, the institution is still going to follow the terms of the contract. Now, there's a state statute that's out there to help with that and to try to overcome that. But imagine a situation where the ex-spouse has already contacted the life insurance company and collected the proceeds, and now they're gone. Well, you might have a legal right to those funds, but just practically speaking, that's going to be very difficult to recover. There's also the employee benefits that prevent you from designating a beneficiary other than your spouse. I know that when you sign up for a 401k or something like that, oftentimes you have to put your spouse down. And if you don't, a big warning box will come up and it says that your spouse has to actually sign a document saying that they're okay with you listing someone else. And that's because of the employee benefits that you're required to provide those to your spouse. The biggest issue we see with beneficiary designations is that they're just not kept up to date. People get divorced, or maybe a spouse passes away and then they get remarried or something like that. In those situations, they fail to update the beneficiary designation, and it can create conflict and real issues later on. Okay, so that's beneficiary designations. We mentioned this early on in the presentation, the idea of a blended family. And of course, when we are dealing with that, some complications can arise. The blended family, again, involves a second marriage, and it involves children from a prior marriage. So that's kind of what we're thinking of when we talk about a blended family. Especially if both spouses have children from a prior marriage, their estate plan should reflect that. And what they will most likely want to do is they'll most likely want to provide something or everything to their spouse. But at their spouse's death, they would then want those same assets to be then distributed to their kids, and not necessarily to disinherit their children. That's very unlikely that would occur. The challenge then lies in providing for your second spouse, and then also making sure that your own biological children receive their inheritance accordingly. It's also very difficult to decide who to appoint as a fiduciary in that situation, because if you pick your second spouse and they do not have a good relationship with your children, you could be setting everyone up for conflict because of distrust or poor relationships. So there's some things to think about when we deal with blended families, and we have seen so many varieties that we have some really good strategies that we usually are able to apply. Okay, some misconceptions that we deal with all the time, and I'll go through these quickly. Love conquers all. I've had this comment said to me multiple times. Well, I don't need to really worry about this because everyone in my family gets along, or love conquers all. I think the next slide is that one. There's some real obvious limitations to that because relationships change, expectations might be off. It's unfortunate, but these situations, large inheritance can bring out the worst in people. And it can make it to where your loved ones just don't get along much after. And so we encourage people to clearly spell out what those expectations are. Communication conquers all. How about this one? I just want to keep things simple. I don't really want to deal with the complexity of this because I just want it to be simple. I had someone ask me one time, I just want you to draw up a will for me that is one page. And of course, I'm an attorney, so that is totally impossible. But for very practical reasons, that's just not, it's going to miss some of the key things that you might want to think about. And so the point there is striving for simplicity may only increase ambiguity. It may make things ambiguous, and then, of course, you're creating conflict, or you're setting people up to create conflict. This one I already mentioned. Everybody in my family gets along. I don't have to worry about this. Everybody gets along. What we want to make sure of is that if you pass away or if something happens to you, that everyone continues to get along. Because again, a lot of this a lot of conflict that we see could be prevented with the proper estate plan. Okay. We talk about, if you come meet with us, we almost always are going to talk to you about trusts. That's a big part of what we do, and maybe you are familiar with trust, maybe you're not. I like to go over the terms of a trust. A trust are kind of what the pieces of a trust are. A trust is a relationship between parties for the benefit of someone else. So there's three parties to a trust. There's the person who sets it up, there's the person who's in charge of it, and there's the person who benefits from it. Those are the three parties that are listed there: the settlor, the trustee, and the beneficiary. A very simple example of this would be if I were sending my children to my brother to stay with him for a week. and I gave my brother $200 to spend on food, I have created a trust relationship. I'm the person who set it up. My brother is in charge of the money. He's the trustee, and my children are the beneficiaries. They benefit from the proceeds and whatever my brother spends it on. So that's the nature of a trust relationship. But when that is set up, that trust is its own separate legal entity. So you can set up an entity, and you do it through a trust agreement. You can fill all three of those roles at the same time. You can set up a trust that you are in charge of and that you benefit from. So that's the nature of a trust. And we don't really spend too much time on irrevocable trusts. What we're talking about is a revocable trust, one that you could change. Irrevocable trust is usually for more complex estate planning needs. Some benefits to trust. A trust is something that's private. A will is not private. Trust can help you avoid probate. If you put your assets into a trust and they're not in your name, then you will most likely not meet the requirements for probate. And so you can avoid probate. And then trusts usually allow for better planning for disability. And the really simple way that I explain this is if you think about a will, when does a will become effective? A will becomes effective at your death, not during your incapacity. A lot of people, there's a very high statistical probability that you would become incapacitated prior to your death. A lot of people do. And so it's that period of time that we also want to think about. There's some limitations to using a financial power of attorney that a trust can prevent. So a trust can do a little bit job of planning for disability. When does a trust become effective? As soon as you sign it. So a trust becomes effective immediately. A will becomes effective only at your death. So that's a way to remember that. There's some also, here's some other things that you can do with a trust. And this has to do with after you're gone. So you can set up a trust for your family or your children after you're gone, and it can provide asset protection. It can protect against remarriage or financial elder abuse, which is a crime. It can also control your assets better from beyond the grave. And then, of course, there's if people with taxable estates and really advanced tax planning needs, we can use trust strategies to assist with that as well. Some other planning documents to think about as it relates to your relationship. Who's going to manage your healthcare decisions? What have you said you would want to have happen to you in the event of life-sustaining procedures or artificial nutrition and hydration? That's a living will. If you were in a persistent vegetative state, or if you had a terminal condition, how would you want to deal with end-of-life treatment? Who has access to your medical records and files under HIPAA? If you have minor children, who are you appointing to be their guardian conservator? And then how would you dispose of your final remains? You can spell all of these things out in proper estate planning. Okay. So some final things to consider, and then we'll open this up for some questions. First of all, if you are in a relationship with someone else, are you clear on the status of your relationship? And if you are claiming that you're common law married, what is the evidence of that? Have you thought about, if you're in a relationship, have you thought about protecting your spouse or your children from remarriage, making sure your children receive an inheritance from you and accommodating those blended family concerns? Or how about this? Have you recently gone through a relationship change? Maybe you've entered into a relationship, or sadly, maybe you've just come out of a relationship. Well, those are relationship changes that usually require attention to your estate plan, because if your estate plan was set up while you were in the relationship, it's probably no longer accurate. Specifically, beneficiary designations or property ownership. That's a big one. We had someone come in whose spouse had died several years ago, and I think like 11 years ago, and they had never taken their spouse's name off of the property. So now they're trying to transfer it again, and we had to go back and fix that and clean that up, and we were able to, but that's an issue. Who would be in charge of making decisions for you? Do you still have an ex-spouse on there, or do you have someone there that shouldn't be there anymore? Well, those are some things to consider after a relationship change. Okay. This is kind of more marketing here, or solicitation, just putting it together. One of the things that we talk to all of our clients about is making sure that the assets that you have work with the legal documents that you've put in place. If you have beneficiary designations and they're going to specific people and your will directs them to go somewhere else, well, then they do not work together. And so you want to make sure that those assets do align and that your beneficiary designations and the way that you own property fits with what you're trying to accomplish. That's something that we're going to work with all of our clients on. And then changes. What about changes in ownership, moving, changes in beneficiaries, changes in the law, changes in your health, and more? So keeping it up to date, I have a meeting scheduled for next week on someone that I met with several years ago. We're going to review what she has. We're going to review the new laws that have been passed and just make sure that everything's up to date. And so that's a good exercise to go through every now and then. And then, of course, we would be happy to work with you. Our number's been, I think, on every slide. You can contact us at that number there. And we'd be happy to review your estate plan where it's at, or if you do not have an estate plan, that's fine too. We can start there. We just want to make sure that you have the education that you need to make the best decisions possible. So that is the conclusion to our presentation. Thank you so much for attending. Hopefully this was helpful. I think, Colette, you probably will encourage them, but if you know someone you think might benefit from this, please feel free to share it to them. And if you have any questions, I'll be here for the next couple of minutes and we can address those.
Wonderful. Thank you so much, Tim. I've got a weird echo. Thank you so much, Tim. Thank you for being our good bad guy. You heard Tim say it. If you can use his advice in this presentation to advocate for yourself for any of these kinds of issues that are really important when it comes to protecting yourself and your assets and your family. We'll open for questions if anybody has any. Tim, I will mention there are a few people who signed up who I knew would not be on, but they are looking forward to watching the recording later.
Great.
For those of you who are on, you probably know this, but if you forgot, this video will come to you in the form of an email and a link. It takes a while because the video has to buffer, so sometimes it'll even take a few hours. But you'll get an email after with a link to the replay, and that's what you can share with friends and family. Anyone who you know who is going through some sort of relationship change and needs this advice, you can share this. I'm also going to post it on the website where I post all of the recordings, so you can watch it anytime or you can share the link anytime. And Tim, I'm gonna end the meeting now, but if you can stay on, I'm not sure if it'll let you stay on. I do have one other thing I wanted to ask you about as far as a future class date. But if there aren't any questions, I will just thank you so much for joining us today and thank Tim for all of his wonderful advice. As always, we're so lucky to have him on here. He's going to be back. I'm sure I'm speaking for him, but I'm sure he will come back. His other classes that he does are what to do when a loved one passes, which is the one I want to talk to you about, Tim. And then the understanding wills and trusts. Those are our other two that he does. So be sure to join us for those. And then our next class that Joanne and I are doing is minimizing taxes in retirement on March 10th. So if you haven't signed up for that one yet, go ahead and do it. And I'm going to end the thing. And if it kicks us off, Tim, I'll just give you a call. Okay.
Thanks,
everybody.